It's up except for, right? Is that? Yes, except for the training we have to, go to, so that'll wrap up the regular meeting portion. So thank you all so much for being here. I think you're welcome to stay for the last.
Yeah, it's here.
It's right here. It's, sure. That's good.
So we're going to start the training at 2:30. So you've got 10 minutes to get a snack, use the facility, stretch your legs.
Okay. I have the power. Was that? That's He-Man. Sorry, my bad. Okay. All right, sure.
All right, I'm going to turn it over to General Counsel Julie Shanklin, who is going to introduce our presenter.
Hello, I'd like to introduce to you Clarence Bellingham, who has agreed to do our annual anti-harassment training this year. Clarence Bellingham is a regional managing partner of Fisher Phillips Portland office and a partner in the Seattle office. He's a trial attorney focusing on employment litigation, including disability, race and gender discrimination, retaliation, sexual harassment, and wrongful discharge. He also represents employers in wage and hour claims, employment class actions, and traditional labor matters. He also proactively advises clients about labor and employment matters, helps with employee handbooks, and provides client trainings, including to us. Thank you very much.
Thank you. Well, it is an honor to be here this afternoon. I think I'm the last speaker of the day, so I appreciate everybody's patience and attention as we sort of wrap up. The sun is setting off to my right, so everybody here looks like a blur as the sun sort of blocks me out. But I do appreciate the time speaking with folks today. This is a really important topic, but one folks just hate to talk about because of the nature of the issues and the concerns. And so often I find that people think they know what the rules happen to be, and therefore they judge themselves accordingly without necessarily fully appreciating all the issues that flow from labor and employment stuff. So if I could have this next slide, please, or the first slide. Thank you. All right. Can we do the slide? There we go. Next slide, please. So what we have here is a representation as to why this matters. And there are various reasons why we're going to talk about why this matters. What I normally do when I speak about this issue is I go in and I pull up some of the most recent lawsuits that have popped up, and I take little snippets of those lawsuits and I put them on this slide so we get a flavor for what happens. Look, when we're dealing with anti-harassment and anti-discrimination issues, these things make headlines. These things are noteworthy, and these things reflect on you as an individual if you're not careful. Slide, please. We, in our careers, at some point, we're all going to be remembered for something, right? In our respective tenures at our firms, in our organizations, in our agencies, in our practices, in our time with the Board of Governors, you will be remembered for something. Right. So the real question one will ask or should ask is, what will you be remembered for during your time period? The issue that we're going to cover today is important enough because it could be, frankly, a stain on your legacy if there's an issue or there's a concern that's raised. It's an important issue and one that folks need to track. Slide, please. All right. Now, we're going to talk a little bit about why this is important beyond those first few slides that I noted. We're going to talk about definitions. We're going to talk about rules and policies. I'm going to read just a smidge from the bar's rules or policies regarding this, because I think it's really important that we cover those issues. Now, this is an interactive process. You could choose to ask questions as we go through. Again, everybody's a blur over here, so I apologize, but I should be able to see a hand if somebody raises it. And I am told you're not a shy group, so I encourage the interaction. All right, slide, please. All right. Look, at the end of the day, it's really important to note that when these things happen, when there's harassment or when there's discrimination, right? And there are real issues that are out there, that it implies by definition that there's a real victim or somebody who is the recipient of that conduct. Suffice it to say, the bar in general has a zero tolerance policy, and the Board of Governors should have a zero tolerance policy as well. The bar's mission includes serving the public, ensuring integrity, and championing justice. And it is hard to live out those things if one has engaged in this type of conduct. It undercuts the credibility of the bar in general and of the governors, frankly. Slide, please. You know, it's one thing I love talking to lawyers. If I was in a room of non-lawyers and I asked them how much does a piece of litigation cost, I get various numbers from $5,000 to $1 million and all places in between. Suffice it to say, as I talk to you, esteemed colleagues, that you recognize already the cost associated with a lawsuit. Not only is it time consuming, it is time consuming and resource consuming, but personally it is draining. So there's a personal cost and there's a professional cost, and there's also an economic cost to these things, right? Lawsuits hurt the reputation, not only of you, but of all involved, and frankly, of this esteemed institution as well. So to say it is costly in many ways is an understatement. Slide. I was having a conversation with a colleague the other day, and the colleague asked me, why is it you work where you work? I said, well, I have to love what I do, but in addition to that, I have to really like the people I work with, because half of it is me doing what I love, and the other half is me enjoying the people I work with. And the same thing goes for those folks who, frankly, interact with the bar in a professional perspective. Frankly, they want to enjoy their profession, and they want to enjoy the people that they have the honor of practicing with. So professionalism does lead to higher productivity and higher morale, and we all want to be someplace, hopefully, where we feel valued and appreciated. So, and also that also decreases the cost associated with turnover, and make sure that folks want to be where they are. Slide, please. It is extremely common in these situations in where an issue or concern is raised, that the individual raising the issue or concern feels the need to also, whether for strategic reasons and where the lawsuit could be removed to or not removed to, or for whatever other reasons, or to make a point, will, in addition to filing a lawsuit against an organization, will make sure that they name several individuals in their personal capacity. And we'll talk a bit about it, but there is personal exposure for not getting this right beyond what the organization's exposure would be. And then, of course, having a judgment is a very public thing. And again, I know I'm proverbially preaching to the choir. You guys know all of these issues already, but you'll have to bear with me as I remind you that a judgment is an extremely public thing that does not go away just because you wish it to go away. And then at the end of the day, once that process is done, the bar itself will hold you accountable for the conduct involved or at issue. So again, many ways in which an adverse determination or finding could play out. Slide, please. It wouldn't be a talk about harassment and discrimination if we didn't spend just a little bit of time talking about what the definitions happen to be for these issues. So we're going to do that now. Slide, please. Protected class. The law recognizes and carves out numerous immutable characteristics that an individual has, and says that these immutable characteristics have no bearing on one's ability to do their job or shouldn't be a factor. For example, race, gender, and various other things that we'll talk about. So these things are protected by law from discrimination and harassment. Characteristics that may not be considered when making employment decisions or considering any adverse action. And you should not target anybody or treat anybody negatively or engage in any adverse actions towards anyone as a result of those immutable characteristics. Slide. So often, as a person of color, when I ask about these issues, people will normally get to things like race, but gender identity, for example, obviously sexual orientation, disability, veteran status. If I were to ask a group of individuals here if they were in a protected status, some might feel that they are not. Let me assure everyone in this room and watching via the internet that everyone is in a protected status or 12. All right. If you take one protected status, the flip side of it is also protected. If we take race, right, I am a person of African descent, right? And if I were not a person of African descent, my race would still be as protected as if I were somebody of African descent. All right. Everybody is in multiple protected statuses, although sometimes folks will think that that does not apply to them. Slide, please. Wow. The concept of discrimination is extremely broad, very, very, very broad. We try to capture things such as, well, you can't choose somebody negative in the hiring or promotions or layoffs or resources or things of that nature. But basically, it boils down to anything that could be construed as an adverse employment action, right? Or an adverse action in general. For example, if there was an opportunity that was presented, a unique opportunity for training or for an experience, right? And you said, well, I'm just not going to give it to everybody in the room wearing a yellow tie. Well, if everybody were in the room wearing a yellow tie, happened to be, for the sake of argument, in a protected status, right? And he was the only person in that protected status, right? Then arguably, if that's the reason why I said not the governor with the yellow tie, then that could be construed as an adverse action, because I am targeting that individual, even though I try to characterize it in some sort of a neutral fashion in order to get around it. The real question is whether or not, again, those protected statuses were a motivating factor in taking the action that I did, right? So things like evaluations, assignments, things of that nature. One of the things when I train in to a normal work environment, I give the example of two individuals, for example, and maybe somebody says, well, Clarence, you don't have any kids at home, but I know that the gentleman, the governor with the tie, does. So I'm going to let the governor with the tie go because I need somebody to work late tonight. You probably have more free time than the other person. Wow, I could drive a battleship through all the issues that flow with that. Sometimes these issues that trigger a protected status are way more subtle than folks fully understand. And you have to be careful in what you say and how you represent yourself. And we're going to talk a little bit about emails in a minute and how we get the communications in that. But I don't want to get ahead of myself. Slide, please. Harassment. Offensive, intimidating, or hostile behavior, related to any protected characteristic that unreasonably interferes with work performance. So it has to be, the concept is truly severe or pervasive. It just can't be anything truly minor from the harassment perspective. Objectively offensive behavior, as well as subjectively offends the victim. All right. So I'm going to pick on the governor with the yellow tie. Can I be so kind to do that, sir? Right. And the governor with the says, hey, Clarence, I have a joke for you. And he comes and he tells me a joke, and it's an inappropriate joke. Right. And I say, well, you know what, as a vet myself, all right, and having served in the military and being enlisted, I heard many a joke, and I'm sorry, that is just the saddest excuse for a joke I've ever heard. But not to, I'm not moved by it. I'm not offended by that joke, right? But then the governor says, well, Clarence, I take that as a personal challenge, right? And keeps coming back and up in the ante. At some point, you can cross that line with me, right? Because again, there's an objective and a subjective component. So where I might not have been subjectively offended by it at some point, right? At some point, if you continue to do it, I could be subjectively offended by it. More importantly, let's say you and I have a disagreement, right? And maybe I am not subjectively offended by what you've said. But now I'm mad at you because you and I have a disagreement. And now I say that I am subjectively offended by it. At that point, it does become an issue, right? Because again, it's kind of hard for you to quantify whether or not I'm subjectively offended by the joke or the comment. All right. And we're going to talk a bit about the implications of conduct that may not necessarily cross a line from a legal standpoint, but still itself may violate the bar's policy and still subject you to discipline or some sort of corrective action. Slide, please. So this is one of those slides that talks directly to policy. So I'm actually going to read portions of it because I really think it's important for you to understand the rules that you're supposed to be subject to already. The Board of Governors Anti-Harassment Policy and Procedure says engaging in any act that discriminates against an employee because of sex, or should I say any other protected status, will not be tolerated. So that's your current standard. No one will suffer retaliation for reporting workplace concerns, including but not limited to that an employee who believes that the work environment has become a hostile or offensive place to work. And last but not least, this policy applies during normal working hours, at work related or sponsored functions, and while traveling or on work related business. Now, that's broad. So again, it's really important to understand that's not something aspirational. That's what you're already supposed to be complying with in every way, in everything you do, and how you conduct yourself in and around wherever you may be, frankly, on behalf of the bar. Slide, please. Quid pro quo. I just love lawyers. I love law school. It's the only Latin I know. I'm grateful for the little I picked up in law school, and I love it. But quid pro quo, this for that. When someone in a position of power, and that would be everyone else sitting around this table, right, offers a job benefit in exchange for sexual favors or for favors in general, threatens a job detriment if an individual refuses. So let's take the governor who was so kind to allow me to, and I'm sorry, I just can't, you see, you gave me permission now, I'm going to go with it, right? With the LSI, right? So he says, Clarence, there's this new movie coming out. And I want you to go to the movies with me. And I was like, sir, I'm sorry. I'm just not interested in going to the movies, but I appreciate the offer that you asked me out, but I'm not interested in going. And he says, well, since you are not going out tonight with me, you know, we've got these other things of this project we need to move forward. I'm assuming you'll have some time. So you'll be working later today. This for that. Right? It is conditions. Sometimes people think they're slick and they try to condition them in ever so subtle ways. And that is very much a form of harassment, right? A bargain for exchange. If you do this, then I will do that. Slide, please. All right. So let's talk a bit about types of behavior that we obviously see. Look, there's no way in which we can capture all of the ways in which people interact. You know, again, normally when I train in workplaces, I say the high school is alive and well in your workplace. You've got every single social group that you would normally have that you grew up with in high school just playing out in the workplace, right? And all of the issues that flow with them. And we cannot possibly characterize all the conduct, but we're going to try to just touch on some of the more obvious things. Governor, did you raise your hand, ma'am? Sorry. That's fair. I thought you had a question. I got excited. It's okay. It's all right. All right. So some of the obvious things, look, You can read the slide as well as I can. I want to talk to the huggers. Now, they're amongst us. I don't know everyone here to the point where I can say who the huggers are, but some of you are huggers and you just have to hug. And I get it, right? You want to hug because it's Saturday. You want to hug because it's Tuesday. You want to hug because it's overcast, right? You know, we lost our quarterback to Denver, so we got to hug it out. I get it. All right. So, it beats the Eeyores in the room, and I don't know enough to know who the Eeyores are, but some of you carry your own personal cloud. Different training, different day, right? But let's talk to the huggers. In truth and in reality, one needs to be careful in that you're not invading, frankly, the space of other folks. You should not be making physical contact on a regular basis with others, frankly, when they, without making sure that it's all that they're okay with that. Do not presume because of your friendship or your connection with somebody that they're okay with it, right? And when in doubt, ask them. Again, I'm told that the folks at this table are not shy, right? And you'll be quite clear with each other where you stand with each other, right? Now, of course, we're not throwing the baby out with the bathwater in the concept of if I were to have, and I'm going to pick on the governor again with the yellow tie because he was so kind, sir. And again, I can't see the name tags at this angle. And I apologize. Your name, sir? Governor, can I call him Governor Dan?
President Dan.
President Dan, sorry. Of course. I can't see. The light is all messed up and it's at an angle. So now I'm in trouble. See, if I lose my job, it's an adverse employment action, folks. I just want to note that for the record. Now I so lost my example that I was going to use. I have so lost that example now. But look, at the end of the day, you have to be respectful of everybody's space and everybody's consideration. So yes, thank you. I do know where I was going to go. I have perhaps suffered a personal tragedy, and the president of the bar recognizes that I have suffered this personal tragedy. I've lost perhaps someone close to me, and in the context, he consoles me, right? Again, I would find that to be appropriate in that circumstance, right? But no offense, Mr. President, if you were coming up and hugging me every 5 minutes, every time you saw me every day, at some point we would have an issue. Again, we're not ignoring the context. I'm pointing out that one needs to be respectful of the space of others. And you need to make sure that frankly, in a perfect world, you wouldn't. And if you feel the need to hug or engage with somebody else, that you make sure that you have the consent to do so. And I think that is the best practice. Slide, please. I'm never going to live that down, by the way. That is fantastic. All right, verbal behavior. Well, no one does, whistling or cat calls is obvious, right? But more sexual innuendos, use of profanity, mocking, slurs, things like that. So Recreate, I'm going to pick on the president again. I'm so sorry, sir. You gave me leeway, so we're gonna go with it, sir. And I apologize in advance. So he asked me out on a date. Right. And I say, well, no, sir, I'm not interested. Right. Now, that probably in and of itself is fairly innocuous, although there could be some power dynamics going now that I know exactly and I could see, there. So maybe if that doesn't cross the line, if he keeps coming back to me every day going, are you ready to go out, Clarence? You're sure you don't want to go out? Again, we get into that same scenario where we start to cross a line on those issues. So anyway, it's important to track those things, but I want to move to the next slide, please. Visual behavior. I'm told that is anybody here old enough to, like myself, to remember a commercial? I believe it was one of the beer commercials that I can't remember when it was, but from a while back, from many Olympic. And they had this thing where the Swedish swimsuit team, these models went across the United States and they would come out and ask for directions. and somebody would give them directions or whatever else. I am told, or I read someplace, that the company that they had all these ads and things that they put out was sued for its policies. And when I thought, well, who would sue the beer company for their advertising campaign? It was my understanding, and I'm sure somebody out there can correct me if I'm wrong, that they were sued by their own female employees at the head office because they were putting up their own ads and things of that nature in the workplace, and they found them to be insensitive and towards women, right? So visual images matter. What you write matters. The notes, how you characterize issues matter. Your text messages matter, right? Now, we especially since the pandemic, everybody's accustomed to working remotely. That gave a lot of folks a lot of license to put things in email and text messages that they thought maybe they shouldn't, right? Keep in mind that those things are all discoverable, right? And admissible as to what was going on or the thought processes or the issues or concerns being raised, right? And if I were to print an email, it looks a lot like a memo: to, from, rate, date, subject matter, right? And everything else. I often talk to folks, talk about my younger brother. I have a younger brother who's a wonderful soul, but an extremely inappropriate guy. And he likes to send me the most inappropriate stuff. And I'm like, dude, you really can't do that. You know what I do for a living, right? And he doesn't care. He thinks it's funny because he's my younger brother and he's not a lawyer. So he can have a sense of humor. But then I've got it's like, you can't email me at work, right? Because I don't want any of that stuff showing up in my work email. Frankly, I don't want you emailing me at home either. You can just call me up on the phone and tell me what you had to tell me, right? And he thinks he's funny, right? And we all have our own younger brothers, our own, I'm not going to say his name, but we have our own individuals like that. We have to be careful with the information that we have access to and that we allow to come through our computers, through our phones, through our email systems, through the bars, email systems and communications and things of that nature. And that should not be perpetuating any harassment or discrimination or gender biases or things of that nature. Slide, please. Because of treating someone differently because they don't conform to a stereotype. And, you know, we hear these phrases that are kicked around. Somebody needs to man up, or she needs to be softer and gentler in her management style. These are things from the slide or statements that people make as folks bring their own stereotypes into the workplace or into their professional lives or their interactions with others. And I get we are all raised in different households with different views and different standards, but the requirement is to be professional through the bar at all times. The requirement is to not let those types of immutable characteristics be a factor in anything that is done. And for your own legacies and reputations, right? The best practice is to make sure that you do not let these things be associated with you or be a factor in how you conduct business so that, frankly, you can best represent the bar and, frankly, yourself. Slide, please. Where can harassment occur? Well, anywhere. You know, I call it the Applebee's test sometimes, truth be told. If we're all going to go and we're going to say after this Board of Governors meeting, we're going to go down the road to Applebee's, right? My guess is most of us have a car that seats 5, right? Which means that as much as you like each other, if you're driving, that means at least 4 slots for everybody else, right? And truth be told, you may say, oh no, Clarence, I love everybody. We're going to take all 20 of them to Applebee's. Really, you're going to go, I've got 1, 2, 3, 4, and we're going to go to Applebee's together. And we're going to talk about issues because you're like-minded in one reason or another, right? But, you know, we're lawyers. What you say can and will be used against you in a court of law. remember, you are always on. You always represent yourself personally, right? And your conduct is a reflection of your status as a governor or your position as a governor. And your conduct is a reflection, frankly, of the bar in general, right? So what you say, even amongst folks that you take who pass the Applebee's test, you never know where that information is going to end up. Judge yourself accordingly, conduct yourself accordingly, and remember that you never quite take off the hat that you wear as a board of governors, and as a member of the board of governors, I should say. Right. So off premises at sponsored events, social, you say, well, I'm going to have that barbecue in my backyard on the 4th of July. Right. And then you have folks from around the bar, and then you espouse views that are inconsistent with, frankly, the rest of this training that we've just talked about. That again reflects negatively both in your status personally, professionally, and frankly on the organization that is the bar. So your messages, your voicemails, your text messages everywhere. And that's what comes, frankly, with being a member of the Board of Governors, is that level of accountability, recognizing that you never quite step away from that role. Slide, please. So, often we find, at least I find when I go and I deal with these issues, somebody says, well, I didn't cross the line legally. I was like, okay, all right. Well, you may not have crossed the line legally, but you definitely crossed one, perhaps as a lawyer ethically, or frankly, through the bar's policies, right? And that will be dealt with or must be dealt with depending on the nature of the infraction in the appropriate fashion. So one-liner remark or inappropriate joke may not violate the law, but it may be inconsistent with the policies of the bar or, frankly, your ethical obligations. And harassing behavior does not need to be illegal in order for corrective action to be considered. And I see this play out in many a conference room when I explain to somebody that their conduct, while may not cross the bounds of legally being inappropriate, it violates an organization's standards, and therefore the organization wishes to disassociate itself with that individual. Again, repercussions, consequences. Slide, please. I love let me rephrase that. It is interesting when I have the conversation with somebody who has been accused of wrongdoing, because it is not uncommon for the individual to then try to justify their conduct after the fact, right? I'm a good person. I'm not sexist, Clarence. I am whatever it is, fill in the blank. I'm not racist, Clarence. I know other people of this persuasion or whatever the justification is. Let me assure each and every one of you that there is no excuse for violating these policies, and there's no justification that you'll be able to offer that will make it appropriate. And to the extent that the bar needs to look into those issues or respond to those issues, it will do so. This slide is a list of excuses that I am commonly, or folks like me commonly hear from folks, and they're not substantive in that they will not prevent a review or look into any issue or concern. I thought it was consensual is when we hear the other person laughed, or I've got my First Amendment rights, and I'm sure they're lovely rights that you have. But if they violate a policy, then the organization will need to enforce its policies. All right. So it's important for you to understand that. I'm sure everyone here knows that already. Slide, please. Slide again. You overhear two employees on break calling each other culturally insensitive names. You know they are friends and they are joking. Neither of the employees complains to anyone. Is it unlawful? I'll give you a different fact pattern, a similar one for us to discuss. Years ago, I was called to look into a situation in which two individuals of African American descent who grew up together in the same neighborhood and knew each other would commonly refer to each other using the N-word. And they had a friend who grew up in the same neighborhood with them, who was not of African descent, but because they grew up together, that person had permission from the other two to be able to use that term in conversations when the three of them had a conversation. They worked in the same environment, except now, of course, some of the peers heard the phrase being used and they determined to use it. At that point, the individuals of African descent determined that they no longer wished that term to be used, and then they complained. So let's talk about those issues. If folks feel comfortable weighing in on that, and if you don't, I'm happy to walk you through how that issue was resolved. But again, was it unlawful for those two gentlemen of African descent to use that term in referring to each other? I will help you through that one because that's a difficult situation, and I will spare others there having weighed in on it. When the issue was presented to me, I recommended the termination of everyone who used that phrase, irrespective of their cultural background. It was inappropriate and violated the policy of the organization, irrespective of one's background, right? You do not get a pass on an issue or being culturally insensitive just because you yourself may happen to be a member of that group. That does not give you license to use that phrase or that term in referring to anyone else. And in that situation, those people could be equally unemployed, along with the other individuals who are not of that descent, who then felt the need or the desire to use that phrase. It was unprofessional for that environment, and it was not warranted under the circumstances. I can imagine when it would ever be warranted, but needless to say, it violated the policy, and therefore those individuals were all let go. There were different issues, and I don't want to oversimplify it, but the reality is, again, just because two folks may use culturally insensitive terms that they're not offended by, doesn't mean those within earshot are not offended by them. It does not mean that it doesn't diminish, right, the expectations in the workplace and undermine the company's efforts in order to prevent harassment and discrimination in the workplace. And it is intolerable. And that is the approach that I took when I resolved that situation in that circumstance. Sir.
I absolutely agree that given that it violated the anti-harassment policy of your client, that termination was both warranted and defensible. But you had asked if it was illegal. And I'd like to know what you think about that. I'm not sure it is.
Well, and so from this perspective, I do believe I would disagree, Governor, and here's why. The workplace was bigger than the two individuals. And while they themselves, right, did not object to it, right, others were offended by it. And they have a right to work in an environment free from the discriminatory conduct, right, including the use of derogatory terms in the workplace. So while the folks who were using it, right, were themselves not offended, they offended others around them.
Sorry, what statute did they violate?
What statute did they violate?
Yeah.
Well, again, let's say, for example, my wife, right, worked in that work environment, and she heard that, right? And my wife happens to be a person of African descent, but if she were not, right, she could have been there and she could have been offended by it, right? She could have been bothered that those phrases were used in the workplace. She could have felt that she was being diminished herself, right? She could have felt, for example, our children were being diminished. She could have felt it was hostile towards her. And for example, also she expressed concern about the use of that term in the workplace and received negative feedback from those involved or felt diminished or belittled because she opposed that. That also raises an issue. I'm not sure. I'm sorry. Another hand.
So I actually appreciate the way you laid that out. But one of the things I heard was, this is a policy of the company, a private employer. So statute has nothing to do with it. It is, what is the policy of the company? However, I have the other question, however, because I think if every time that is done and the answer is to immediately dismiss somebody, I'm wondering in terms of trying to manage the company, if that's the best approach. So I'm asking, where is room for the warning? Where is room for restating to the company that this is our policy? Where is room for a suspension? Because while it is the policy, there's also the opportunity for the company to make it clear that this is our policy. And the confusion is, and I appreciate the example you give, because the confusion is, and I've heard it when two African Americans are talking and say, well, it's okay for me to use that term. Now, where they got that from, I don't know. But it becomes the moment where you say, no, it is not okay. It is not okay. And we want to be clear it's not okay. But again, I wonder if immediate termination is the first thing you go to in your arsenal.
Great question. So, Governor, I want to start. Yours is a subtle distinction between what's legal versus a violation of the policy, and I appreciate that question.
Correct.
And you're right, to the extent it does not qualify as being illegal under the law, because it could amount to, it would definitely violate a policy, be a policy violation for which you could be enforced to the extent for which enforcement could be, and I'll get to your question, Governor, in just a second, which could lead to still disciplinary action to the extent that others complained about a hostile work environment or felt it was a hostile work environment because those issues were affecting their ability to work. Because remember, a hostile work environment is one where the conduct is severe or pervasive and interferes with the ability of the individual to work in the workplace, right? And depending on the conduct, it could arise to that level and still then be so offensive or severe or pervasive, right, that individuals don't feel comfortable working in there. And I think that's how we get there, if that answers your question. Governor, your question.
One more thing,
Yes, sir.
because you asked about the statute. If you do nothing,
That's right.
there is, for example, the Washington law against discrimination.
Yep.
And so any of those employees who raise the question, raise the complaint, and you do nothing, you, the employer, can be sued because you have actually now violated the policy against racial discrimination. Because you and in fact, having a policy, doing nothing about it, and not understanding that there's the law against discrimination and making sure that you don't have a hostile work environment or a work environment where you've got the beautiful policy, but anything goes. The statute is there for people who say, well, apparently my employer doesn't care. I'm now going to my lawyer to sue this company.
Governors, there are so many levels to this debate.
I know. We should go on. I apologize.
No. It's a great question. It's a great question. I do want to address the other question raised about the level of sanction, but yours, Governor, is a very subtle question with different issues that are mixed in there and triggers.
Where I was trying to go is that arguably the two gentle people involved in the unfortunate exchange were engaged in First Amendment activity with each other, maybe not. Might not be illegal for them, but it might be legal for the company, depending on what it does.
And Governor, we do not have enough time to do that. I do want to address
Just argue
this
with it.
governor's
Please go.
question as well. On the issue of the level of sanction or discipline, it is important, I believe, for the organization to take corrective action, right? So that it makes clear that that conduct is not repeated, right? Sometimes the severity of the action that is taken will depend on the severity of the conduct at issue, right? But you want to make clear at the end of the day that that will not be tolerated. It is extremely effective, right, to end somebody's employment, to say that's how we make sure that everybody knows. But you're right. There may be gradations of that depending on the circumstances, and I didn't mean to indicate that there was only one answer to that, but I think it's a good answer, and I'll leave it at that, Governor. With that, I will move on to the next slide, please. All right. I think we've already addressed a little bit of this already, the concept of that fact pattern, but having it happen outside of work. And we did a whole Applebee's test, or the Applebee's run. And again, it's the same concept, folks, that we've had, that you are always representing the bar. It's hard for you to take off that hat as a member of the Board of Governors, and you need to judge yourself accordingly. Slide, please. It goes without saying that one of the ways in which we guarantee the effectiveness of the anti-harassment and anti-discrimination policies and practices is to make sure that those folks who raise those issues are themselves in a protected status, right? And there is no retaliation against anyone for having raised that issue. So once somebody brings a concern to the attention of the organization, that person is in their own special protected status for having raised the issue. And that factor in and of itself cannot be used against them adversely in any manner. And so therefore, again, the anti-retaliation provisions. Slide, please. Again, folks sometimes think, as somebody who deals with this in workplaces for private employers on a regular basis, sometimes folks think that they're slick on these issues. But again, participating in an interview, in a hearing, raising an issue, filing an internal complaint anonymously, that's later determined who that person happens to be, or overtly filing an issue or concern, all of those issues, requesting an accommodation for, depending somebody with a disability, complaining about wages. There are various types of protected activity that exists out there. And we need to be cognizant of those issues. When in doubt, check with the human resources component or person or contact individual to make sure that you're not going to run afoul of any of those issues. Because again, you'd be surprised what you think might be okay, and then say, I'm not sure I really appreciated the employee doing that, but whatever that is could in and of itself be protected. And therefore, once you indicate your lack of satisfaction as a result of that conduct and then back it up with something, now you're running afoul and engaging in potentially in retaliation. Slide, please. Again, the concept here is adverse action, some materially adverse or enough to discourage the protected activity. So anything that would be deemed to lessen the risk that folks might bring those issues or concerns again would be sufficient, I think. The bottom line, again, is to refrain from retaliation. Immediately report potential retaliation. That in and of itself is its own reportable event. And again, actively monitor to make sure that folks feel comfortable raising issues or concerns. Slide, please. Next one. Thank you. All right. Bob complains that Alf has been using sexually explicit language and stories during team meetings, which Alf leads. HR takes appropriate corrective action, respects to Alf, and informs Bob that the issue has been addressed. Alf stops inviting Bob to the team meetings to avoid offending him, and because Bob didn't really need to be there anyway. All right. What should you do when you come across that fact pattern? That's right. I think that's right. I think that's right. And the answer was remind Bob that we do not retaliate against people. What else specifically could you possibly do in that scenario? I am not going to repeat that comment, Governor, unless you care to add that one.
No.
That's an assault and battery issue. That's a different training for a different day, Governor. But yes, I appreciate the sentiment.
But here's where, I think it becomes more severe because Alf is at least in leadership, maybe management. And so I'm not sure a warning is at all sufficient, because if he's in a management position, he should clearly know what the rules are. So at least a suspension. And I'm more along the lines of your termination, because, Alf can't, because it also at least appears when I'm reading the fact pattern, he's not going to invite Bob, which at least gives me an indication he's not necessarily not going to continue his practice.
It does appear. So to your point, Governor, now we talk about gradations of discipline, perhaps a written warning or some other documentation to remind the individual that these factors, that should not be a consideration. Of course, making sure that other individual is then invited back to those meetings to the extent that that person had historically participated in them. But you're right that issue needs to be addressed in an affirmative fashion to make sure that we don't, so that the other individual who was disinvited doesn't, it diminishes the opportunity it diminishes the reporting of future events, because somebody says, I complained and then this happened to me. I found myself on the out. And let me say, this fact pattern may seem weird and you're like, okay, Clarence, you're throwing that out. It happens more often than not. You think I see it in private employers all the time. Somebody raised an issue of concern. It is not uncommon when an issue gets raised in the workplace, somebody complains about something and an investigation is done. You can clear the organization or an individual of the underlying conduct. Perhaps it was not because of a protected status or some or immutable characteristic or things of that nature, but now there's bad blood, right? People have long memories. And now they're like, well, I just don't like Clarence. Clarence raised that issue. I had to sit through 2 months of an investigation into my own conduct. And now I cannot stand the sight of Clarence. So therefore, Clarence is uninvited to all these meetings or whatever else. And all of a sudden, I find myself on the out. That is very much, or could be, depending on the circumstances, retaliation. Slide, please. Please continue, slide. All right. We spent a fair bit of time talking through these issues. I actually do appreciate the questions and the response and the opportunity to go back and forth on these issues. But it's important that you know the policy. And we talked a bit and we've read from the specific policy. Again, to the extent you need to remind yourself of the policy or familiarize yourself with it after we're done, please do that. And again, don't think of it as I'm asking you just to read another policy that you may find us interested. Disinteresting or not interesting. Instead, I would think of it from perspective of reading the policies that currently apply to how you should be conducting yourself so that you know how to conduct yourself accordingly is how I would look at it. But know your policies. Again, look for warning signs or issues. You're responsible for spotting them, especially given your roles. You're always a leader. Make sure issues are handled, complaints are triaged accordingly. The reason why you have counsel for the bar and human resource contact individuals is so that you can take that issue and turn it over to the professional who you already have on staff who can help walk you through those issues. Again, it diminishes exposure for yourself and it diminishes exposure for the organization. And that gets to the last point of making sure that the appropriate issues are reported. Slide, please. Being familiar with the policy demonstrates your commitment to it from a top-down perspective, right? If you do not follow it as governors, right, it is hard for us, the rest of the members of the bar, all right? Well, how do I say this? If you look at it and say, look, the governors for the bar don't even follow it, why should I bother doing it? I will always strive to be a professional in what I do, but I do look to you around the table for your guidance and your leadership and frankly, in your unique roles, right? And I appreciate where the bar is in the hands of the governors and the folks around the table. So your commitment to this policy reflects on you, the organization, and frankly, on me as a member of the bar. So be familiar with it. Reporting policy encourages complaints, makes decisions easier regarding reporting, prohibits retaliation, all the things we talked about today. And again, recognizing that there are consequences for violations of the policy. Slide, please. You know, it's often folks say, Clarence, it's not fair to me that I have to be the person to police these issues. Why does it fall to me to have to report these issues? And again, it goes with us, you, I should say, as being members of the Board of Governors, that you need to be cognizant of the warning signs, looking for those issues or concerns. Many of you are leaders within your own organizations and firms, and this is important for folks to note that you're supposed to be able to look for and to be able to identify these issues or concerns so that, again, you know how to report them. Slide, please. You're probably going to go, oh my gosh, Clarence, if you tell me that I'm always a leader, yet again, I'm going to throw something at you. For the last time, yet again, you are a leader and you never cease to be one as a member of the Board of Governors. All right. So we look to you, frankly, to model the good behavior we want to see in other members of the bar, frankly. Right. There's a list of bullet points there. I will not insult you by reading them, but we do, frankly, gauge ourselves in many ways by your conduct as professionals within this profession. Slide, please. Right. It's important that you not let complaints or issues linger. Right. If you are aware of an issue or concern, the most effective thing you can do is immediately hand it off to human resources or bar counsel or whatever your reporting process happens to be so that it gets addressed. It is not uncommon for me to show up in a workplace or in an environment or with an organization to find out that the issue has been lingering for months. And those in leadership have known about it for months and done nothing. It makes you look culpable to the conduct. It makes you look as if you signed off and agreed on the conduct at issue. All right. Again, delays send the wrong signal and can be exploited in subsequent legal proceedings. It's important for you to be impartial. It's important for you to report the issues, and it's important for you to do that as soon as possible. All right. Assure folks who raise issues that their report will be taken seriously. And look, there's the golden rule here. Treat others as you would like to be treated. If I had an issue or concern that I brought, I would expect somebody to treat me with compassion. I would expect to be treated with professionalism. I would expect that somebody would take me seriously, right? Would listen to my issue or concern. The goal is not to be dismissive right out the box, right? And again, if the complaint is against somebody in your Applebee's crew, right? The other 4 seats in your car, right? It doesn't mean that you discount the complainant and say, well, I know, I'm not going to pick on the president anymore. I know that person, and therefore that can't possibly be the case. That is not the right response. Again, be impartial, report the issue, and make sure that that issue is adequately addressed. Slide, please. It's really important when an issue or concern is raised with you, right, for you to remember, right, that this bullet point here, that there can never be an quote off the record discussion, or it's just between the two of us. Many a lawsuit has been lost from an employer standpoint because the manager goes, I won't tell anybody. Once you know, right, that knowledge is imputed to everybody else here. The organization itself is required to act on it. You can't hold that to yourself. That's why it is so critical that you take the time to report the issue in an immediate fashion. You don't have the right to hold it to yourself, right? By you holding it to yourself, you create exposure for all of the governors to your left and to your right, all right? And you also cannot always guarantee, well, you cannot guarantee confidentiality in an issue and how it's preserved, how it's looked into. What you can say is we will try to treat this as confidentially as we can. We will treat this with the dignity and respect this complaint that is due this complaint of these issues. We will be professional in how we look into it. We will do this in a timely fashion. Right? But in looking into and investigating issues or concerns, right, you may need to interview, or somebody on behalf of the organization or the bar may need to interview and follow up with individuals. And you cannot guarantee, I should say, absolute confidentiality, but you can promise that you will try to treat it as confidentially as the organization can in order to let the organization deal with the issue. Slide, please. Again, if there's a horse that I can beat, this is the same one here. Report, be discreet. Do not tell anyone else unless instructed to do so. Again, treat the complaint and treat the complainant as if you were the one making the issue, and give them the dignity and respect that you would have, or that you would expect to be extended to you, extend to them. Where appropriate, provide any notes that you've taken or any issues and turn those over to, of course, to Human Resources. The note here says take notes. Even just a calendar entry can be important. I think it's important for you to capture the fact that a complaint was made. I think it's important for you to note that the issues, I think it's important for you to note that you've turned those issues over to someone in Human Resource or Bar Council who can address those issues or concerns. I'm also a big fan of letting those who will do the actual investigation then follow up and do their own documentation on the issues or concerns, because unless you're well educated and steeped in how we do these issues, I always get concerned about what gets documented and what doesn't. But it's important for you to remember, again, to report and follow the instructions from Human Resources or Council that stem from making sure that report happens, and to capture the information that they indicate is needed so that the organization can follow up. Slide, please. I so do appreciate your attention. I know it has been a long day. I know that you probably didn't want to deal with me at the end of the day, but I have found that I didn't lose a single governor. Not one of you fell asleep during this process. So I will take that as success. Before I go, though, do folks have any questions or concerns that we can address now? Sir.
When you had the example of the team, I was surprised you didn't go to the next level with your Applebee example. And what I'm talking about is Alf also takes his team out to Applebee's. And then I think the other guy's name was Bill or something. things happen, and now suddenly everybody but Bill is being invited to come to Applebee's. Because there's the formal, I'm having my team meeting, but there's this other informal, I'm having my team building, and suddenly a member of my team, well, a member who used to be in my team is in so many ways socially not in my team. I think that could also be retaliation.
I will say that I've got two kids who went through Washington State, go Cougs, and that's my subtle plug. And part of and what has helped for me to put two kids through college and everything else is everybody's 4th of July party and holiday event. You laugh, but it's true. Because the social bonding, right? Not everybody plays nice with others. And you get them in a room and they're bonding socially in the most inappropriate way. The repercussions of those 4th of July's and Christmas events have frankly been, and how those things come back into the workplace and how they play out. Well, they're always there. And then I get those calls, back in August or in January as to, well, you'll never believe what happened at this event. Again, professionalism at all times is important. Recognizing that if folks hear in that informal team building something that they find offensive, right? Or they may have been a member of a group that you referred to derogatorily at one of those events. And then they ask themselves when they come to work or in a professional environment, well, is that the reason why I no longer have this opportunity or whatever else? Or that finally explains why I don't have the same opportunities that somebody else has. Again, those issues are real and they play out all the time. Really important for you to watch what you say and what you do. And frankly, for you just not to be motivated by discrimination based off of those protected statuses, period. I'm not sure, Governor, if that addresses your issue, but yeah, no, trust me, my job, I have as many fact patterns as they are people. We would not have enough time to go through all the examples I could throw at you.
I know I'm not on the mic. I say my question, could someone repeat it? If you're just a member of the Bar Association and an employee comes to you and says something, what is the member's obligation or what is the organization's obligation with regard to what the member has said?
So I might understand the question. And again, is your question as to what the governor's obligation is or what the bar's obligation in general is for a private dispute? I want to make sure I understand the question.
If a lawyer, member of the Bar Association who is not on the Board of Governors is told something by an employee, does that member have an obligation to speak up? And what is the organization's responsibility and response? And we need, for the record, we need to let somebody kind of restate it.
I'll restate it. I think, so the question was, if a member of the organization, not a member of the board, but just a lawyer who's licensed by the organization, receives a complaint from an employee, do they have an obligation to make a report? And then what is the organization's responsibility with regard to any such report?
Let me start by saying we're going to talk about it in the most general of terms, right? But depending on what the nature of the complaint is, there could be ethical obligations that are raised that frankly, you'd have to take through bar counsel, right? But there may be ethical obligations or violations of ethical rules about the treatment of other members of the bar or people in general that may warrant disciplinary action, depending on the nature. In addition to that, individuals who are outside of the organization, by definition, don't fall within the internal bar policies as to how bar employees were to interact with each other or members of the public necessarily. So if it was the complaint dealt with conduct that existed at a private firm outside of the purview of the bar itself as an employer, right, you would have the internal policies or practices to which that organization should have, and that would apply to that situation. Frankly, without knowing more or having a more in-depth fact pattern, it's tough to answer that question. I do believe the answer is, though, that you report the issue or concern, period, so that it gets addressed. When in doubt, I believe it's appropriate to report the issue, because then the human resources function or bar council function can then address whether or not where that falls and what are the specific rules that govern that. But we cannot have that discussion as to that until, frankly, that issue is reported. And I apologize if that answer is not as responsive as I can make it. Well, folks, I do appreciate your time. I'm going to cede the hot seat to someone else. It has definitely been a pleasure, and I appreciate it.
Okay. I did it, yes.
Okay, so I have a comment from President Clark. I wanted to thank each governor, WSBA member, staff, and members of the public for attending today. I also wanted to especially thank every governor and member of this board for their service. Serving on the Board of Governors is a heavy lift, and I really appreciate each of you taking the time to better our legal profession. It is my hope that in the remaining 322 days until the end of FY23, that we make ways to make service more enjoyable and fun. So thank you, and I hope you have safe travels home. You want to adjourn the meeting?
And I want to appreciate you and your leadership and you leading us through this meeting. So thank you, sir.
Thank you, Ellie. Okay, well, with that, I will, okay.